first individual is Katrina Baur. Ms. Baur is referred for party to a crime neglecting a child. There is a probable cause statement. At this point, this is referred for charges. It is not yet a complaint. And it is just that charge. I don't know what the public is expecting to happen today, but I just wanted to set everyone up that this is probably going to be disappointing to what you think. This is the charge. This is what we're dealing with. All right, Attorney Larson.
Ms. Baur's address is Wisconsin Dells 53965. She does not currently have a telephone number. Her date of birth is of 92. She is currently receiving SSDI and therefore is not employed. She has a history of making court dates except for 2 occasions. In 2017, she had a bench warrant issued, but 2 days later it was withdrawn without a hearing. Then she had another missed court in a CT matter, and that was restored to a signature bond within a week.
All right, thank you. We'll hear from the DA, and then my understanding is there are some victims that wish to speak. They do have a right to speak on the subject of bail only today. And then I will give Attorney Larson the last word before I make a decision. Attorney LaBrie.
Commissioner, the state is asking for $15,000 cash bail. We're asking for no contact with the co-defendant, Jesse Vang. We're also asking for no contact with any children under the age of 18. Judge Dietz has already found probable cause. That was done yesterday with an affidavit submitted to the judge. So probable cause has been established by a circuit court judge. The state feels that the cash bond is warranted based upon the facts that are listed in the affidavit before Your Honor, as well as the fact that she intentionally sent that child for disciplinary reasons for more than a week to the residence. She was aware of the tactics used and the lack of care provided. This was an intentional thing by her. And on at least 2 occasions during interviews, she has provided false information on her whereabouts during the past week. So there is a concern of providing false information to officers. So there is additional charges of obstructing that will be coming. She does not reside in Manitowoc County. She does have, as Attorney Larson referenced, some prior matters. She has 17 CT 752 out of Outagamie County, where I counted 4 missed court appearances. February 1st, 2018, where a bench warrant was authorized. That was returned on warrant February 9th. May 16th, 2018, bench warrant was issued. Return on warrant was May 23rd. On August 14th, 2018, failed to appear for the plea hearing. Bench warrant authorized. Return on warrant October 19th. November 6th, 2018, failed to appear. Bench warrant returned on November 15th. Then in 17 CT 236 out of Outagamie County, there was a missed court on June 21st. The return on warrant was June 23rd. She also has 2 prior disorderly conduct convictions, one from 2015 in Outagamie County and one from 2011 in Winnebago County. I think she, based upon her lack of ties, the seriousness of the offense, the prior missed court appearances, that a significant cash bail is warranted, and I would ask the court to impose that with the other conditions requested. Thank you.
And I'll just review, it was the no contact with persons under the age of 18 and no contact with the co-defendant.
Correct.
All right, thank you. All right, so at this point, the victims that wish to speak can come up. You need to come up to one of the microphones. You do not need to identify yourself.
My family and I are requesting a no cash bail. They are the last 2 to have seen our baby Elijah, and at this moment are the prime suspects. So until we find the truth as to the whereabouts of Elijah, we'd like to make sure that these two are readily available for questioning. In the case where bail is given and made, we ask that the person on bail will have no contact with anyone under the age of 18 years old and the families of the victim. And that is all I have.
Right, thank you. Someone else? Or no? Okay. All right, that's the only victim that wishes to speak. Attorney Larson.
Commissioner, I would just indicate that Ms. Bauer does not have any cash to post. She does receive SSDI. She does qualify for an attorney through our office, and she has no significant assets. I understand that she lives in Wisconsin Dells, but she does reside in the state, and she will appear at all future court dates. We ask that the court take those factors into consideration.
This court has neglect charges before it fairly regularly. This case, though, has drawn the attention because we have the missing child involved. And that, of course, pulls that court's feelings and emotions and heartstrings for the care of the child, but it doesn't change the nature of the charges from any other neglect case. And I think we have to keep that in mind too, that that's what we have right now. I've seen the probable cause statements. I know there's more specifics about the alleged behaviors, tactics, as I believe Attorney LaBrie referenced it. I suspect that as charging decisions are made, there could be other charges added. The mother, though, was not present. She knew. That makes it the party to the crime or enabling the behaviors. The lack of immediate ties to the community are something I can't consider. The likelihood that there would be additional misses. While the family is saying low cash bail, they want the individuals to be available. If they're in the jail, potentially they are available. Now, the other consideration besides the alleged crimes, to also consider the ability of a person to abide by the conditions, which means are they able to post? And it would not appear that Ms. Baur on her own is able to do so. I do not know if she has resources as she reaches out to her extended family that would be able to assist her in posting bond. I thank Attorney LaBrie for mentioning that Judge Dietz had already taken care of citing the probable cause statements. There's no doubt that the information does meet that standard. I am going to set cash bail. At this stage, the $15,000, while substantial, is also appropriate. I'll set that amount with the two conditions: no contact with any persons under the age of 18, no contact with the co-defendant, Jesse Vang. And everyone knows the name, so I'm just going to use it. I don't think there's any point, and we don't usually protect the co-defendant. We've been putting the names in the documents. Now, the next hearing will of course be on Monday, following usual practices. I don't know where we'll be on Monday, but for court, that will be in branch moving to 3, are we not on Monday? Yes. February 26th, 1:30, branch 3. Failure to appear, a warrant would be issued. You have the right to be represented. As noted, public defender will be representing, at least at this stage. And I believe that's everything. So thank you. You can leave the room. All right, we are prepared. We'll go back on the record. This is Jesse Vang. Mr. Vang is referred for child neglect. There is a probable cause statement. I'll just jump ahead and assume that Judge Dietz signed probable cause on this matter as well. I don't have that copy. That is the only charge here as well today. Attorney Larson.
Mr. Vang's address is in Two Rivers. His phone number is his date of birth is of 84. He is currently self-employed. I looked at CCAP over the past 10 years. There was a 2012 case, there were no misses. It also appears that he's on a federal detainer or federal supervision.
I had heard that bit of information as well. Attorney LaBrie?
Commissioner, the state is asking for $20,000 cash. We're asking for no contact with the co-defendant, no contact with any children under the age of 18, as well as absolute sobriety. The defendant, as the court had noted, probable cause has been found by Judge Dietz already. He was the actor that was here in the community, dealing with the victim and utilizing the discipline and the tactics as well as the lack of care. I think there is sufficient probable cause that has also been confirmed by the judge in the affidavits that have been submitted. I am concerned about his appearance in court. He has recently been convicted in 2017 in federal court of conspiracy to distribute methamphetamine. He was incarcerated for approximately 6 years as a result of that and was on supervision when this occurred. I believe there is currently a hold, but that is also being reviewed. He does have prior record in addition to that. He had an OWI first in 2023. In 2007, he had felony bail jumping out of Outagamie County, where aggravated battery and battery were dismissed and read in. He failed to appear for his arraignment on May 23rd, 2008, and the return on warrant was May 22nd, 2009. So he failed to appear for court and did not return for a year later. He also has from 2007 a disorderly conduct, 2006 resisting obstructing out of Outagamie County, that same year possession of cocaine as second and subsequent out of Outagamie, in 2004 delivery of cocaine out of Winnebago, that same year possession of cocaine out of Outagamie, in 2002 battery by inmate, also that same year child abuse out of Outagamie County, as well as a fleeing an officer. He has been incarcerated a significant amount of time over the past several years. He also, while on state supervision in the past, has had 3 separate abscondings in 2009, 2004, and 2003. He has contacts or family in California, Michigan, and Minnesota, so he does have resources outside the state of Wisconsin. I think a significant cash bond is warranted. I would ask for the $20,000 cash with the no contact with the co-defendant, no contact with any children under 18, as well as absolute sobriety. There was a reference in the probable cause affidavit to consumption of alcohol, so I would ask for that condition as well.
Attorney LaBrie, I just want to verify my understanding. This federal detainer is based upon and it's supervision, so it's much like a probation hold in Wisconsin?
It is similar, but he does have rights to a hearing, and I believe there was a hearing today. I don't know the results of the hearing.
All right, thank you. Okay, at this point, if the victim wishes to speak on this case as well, or if there's another victim, this would be the time. No one has to, but this is the time if you wanted to. All right, you think that? Okay. All right, so Attorney Larson.
Commissioner, the misses and that Ms. LaBrie cited occurred over 15 years ago. Typically, we wouldn't take those into consideration. It is referred as a child neglect. Obviously, we're aware that there's questions about whether it will remain as this charge, but currently it is this charge. He is on federal supervision. He is not going anywhere. When the state is asking for $20,000 cash on a child neglect, I think that signifies that the federal authorities are not going to be releasing him anytime soon. He does qualify for an attorney through our office. One will be appointed, but we are asking for significantly lesser cash.
Well, in one way, I've already set the $15,000 on the other individual, so we have a precedent for today's purposes. And it is clear to me that taking the probable cause statement as true for today, he is the one who was present and would be responsible for any neglect resulting in the child being missing or the lack of care. That being the case, we'll set the $20,000. He also has a greater ability to flee and not appear. I don't know how the detainer will work. The $20,000 cash, absolute sobriety, no use of alcohol or drugs, any kind, anywhere, in any amounts. No contact with any persons under the age of 18. Just to make it clear, if there is a 17-year-old in custody, the jail rules will apply to that. That's not going to be affected by this provision. This is when you are out of custody. Additionally, no contact with Katrina Baur. Violation of any of the conditions would be grounds for additional charges. The initial appearance will be February 26th, 1:30, branch 3. Failure to appear, a warrant would be issued, and you do have the right to be represented by a lawyer. With that, you may leave the room.